Hi, I'm James Nickless from Chambers Russell Lawyers, and we're the proud sponsor of tonight's Smart Strata Seminar on bylaws and their enforcement.
This is our sixth instalment of our latest roadshow series on bylaws, asking the question, are they worth the paper they're written on? So welcome. We have some expert speakers that are going to be on a panel tonight in a bit of a discussion format, asking some questions, which I'll introduce to you soon. But before we bring them up to the stage, just a bit of housekeeping. First of all, my name's Grant Mifsud. I'm the Sunshine Coast Archers managing partner for the office. So I think I've seen a lot of you previously and dealt with a lot of your bodies corporate. So welcome. Housekeeping, mobile phones on silent if you have to keep them on, please. Amenities just out to the left and to the right if you need to. And same with emergency exits, so just follow the signs in case of any emergencies. All right, now we're all getting settled. Just a little bit about Smart Strata. A lot of you have already subscribed to our newsletter that comes out weekly. So that's where you get all our expert commentary on everything Strata. So there's the news, events, education. So we've got some courses on there, and of course the supplier portal. So we've got a lot of the suppliers that are on that portal here tonight. So if you're not already subscribed, you can just go to the website and click the subscribe button. Please remember to follow us on social media as well. That way you get all of the latest news and alerts that are happening as they come about as well. Plus these events, you'll see some pictures from these events on social media too. Also, within that website, you've got a lot of news archives. So a lot of the topics that we'll be talking about tonight, you can research those further just by keyword search. So if you type in the word bylaws, you'll have a lot of articles that have been written on bylaws. If you want to go deeper, you can type the word pets, parking, smoking, parties, noise, all those sorts of things that are common issues within bylaws. So a little bit about Archers. The packs on your seats, you'll find some details about the services we offer. Most of you are already with us, but if not, we'll have the networking session later on and we'll hunt you down. But there's also some feedback forms in there. So within that form, you've got the exhibitor passport, which is so that you can go and talk to all the exhibitors and get that signed off for our prize draws later in the night. But there's also a question on there. Bylaws, are they worth the paper they're written on? So please have a think about your view at the start of this session and also revisit that after the session so we can see if your views changed. There's also further feedback on the back there so that we can get more information about what you'd like to hear about in future. So please give us some feedback on what we do well and what else we can do to keep these sessions relevant to you. So as I mentioned, we've got our exhibitor passport. That'll be at the end of the session. We'll have each of them up to tell us a little bit about themselves, and then we'll be having some drinks and canapes after with the service providers that support these sessions. So as I mentioned, with that passport, you've got a $100 voucher that will be given away on social media. So another reason to follow us on Facebook in particular. And also the tickets that you collected at the front, please don't lose those. You've got a very good chance of getting a prize tonight. I think it's about 1 in 10 or even better. So hold on to those. There'll be a quick draw at the end. All right, so let's get into it. Bylaws, are they worth the paper they're written on? So I'll now invite our speakers up to the stage. So if you can all come and join us. And whilst they're coming up, just a quick bit of background about each of our speakers. All right, so we have from left to right, Chris Irons. So with an unmatched perspective on the strata sector. Feel free to shuffle around. So Chris is on the left.
Well received, folks. Well received.
He's a thought leader for strata issues and dispute resolution. For over 5 years, Chris was Queensland Commissioner for Body Corporate and Community Management, which is the only role of its type in the world. After working for a well-known strata law firm, Hines Legal, Chris is now an independent strata consultant working under the banner of Strata Solve, helping clients to untangle their strata issues with tailored solutions. Please welcome Chris. Next we have Andrew Suttie of Nicholsons Solicitors. Musical chairs. So Andrew practices exclusively in strata law. He's a fellow of the Australian College of Strata Lawyers, a fellow of Strata Community Education Queensland, and was awarded the SCA Queensland's President's Award in 2019 for his outstanding leadership in the strata industry. Andrew's extensive knowledge of strata law facilitates strategic solutions to complex matters and the efficient delivery of advice and service across a whole wide range of strata issues. Please welcome Andrew. My notes are actually in the wrong order now, so I'll have to skip ahead to Eric. So Eric van Meurs represents Australian Resident Accommodation Managers Association, also known as ARAMA, which is a not-for-profit peak industry body which represents the interests of people who are involved in management rights. He also owns and operates his own management rights business here on the Sunshine Coast and has done so for over 10 years. Welcome to Eric. And last but not least, we have James Nickless of Chambers Russell Lawyers. So he manages the firm's Queensland practice. He's an expert in strata title law and litigation with extensive experience in general commercial litigation, building and construction disputes, debt recovery and insolvency. James is passionate about advancing the strata industry and is regularly engaged in advocating on behalf of the strata industry to government, the media and to key stakeholders. Welcome to James. All right, so you all saw in the invitations you received the 5 questions, which we're going to go through tonight in a discussion format. So the run of events is to have a brief discussion on stage about each of these topics, getting the perspectives of the different presenters, and then we'll open it up to a Q&A with you to hopefully get to the nitty-gritty parts of these bylaw questions. So to start us off, what are bylaws? So James, would you mind giving us a bit of an overview on bylaws from a legal perspective?
Is this on? Yeah. Yeah, look, happy to do so. When I saw that I had this wonderful topic, I thought I could fill hours and hours. We could start with the Magna Carta, and then by tomorrow morning we might get into the present. And then I thought I'll just start with, is there a definition of bylaws? And happily, the Act provides one at section 186, I think it is, that says the bylaws are the things that are provided in the community management statement under the heading bylaws. Thank you.
Very succinct. And to give this question context, perhaps we should also explore what bylaws aren't. And I'll ask Eric if you can give your input on this, because something that I see commonly misconceived is house rules, and they do have a purpose. And Eric, from your perspective, how do you utilise those within your business?
So first of all, what bylaws are the thing that nobody reads prior to purchasing into a strata title session. But really what they aren't, for a person like myself who manages a complex, when guests come, we have a mixed use, but when guests come, they get behavior guidelines. So we have noise guidelines, we have a pet policy, we'll have a whole host of different things that we'll share with people as they're coming in to stay as guests. But those aren't bylaws. When guests come and check in at the desk, we don't hand them the set of bylaws saying there are 20 other people who are living here, they're owner-occupiers, and these are the bylaws you must follow. We don't hand those things out. So it is, there are behavioral expectations that we in the common world would think everybody would understand and would respect and would gleefully follow. And then we find out there are people that don't gleefully follow some of those things. And frankly, the bylaws document in my office sits deep, deep down in the cupboards, and I never pull it out. But when I have to pull it out, it's because something has gone very, very wrong. And so that's kind of my initial take on bylaws. I could go on for hours, but I'll not.
Okay. Well, we'll get to the next section, and Andrew, feel free to expand further on what they are, but also...
I was going to expand. That was a performance art joke. I wasn't actually finished.
Well,
Yeah,
please.
Sorry, that joke went a bit too far. I thought, well, it's such a boring topic, I'll be funny, but it turns out I'm not funny. Also not good at self-deprecating humour. So, essentially, bylaws are a set of rules that a local authority, a company, a community decide that they are going to govern the individuals that make up that body. And so, yes, they exist in your CMS, and as is properly pointed out, if they're not in the CMS, then they're not a bylaw. They might be some other type of sort of conduct rules that the scheme would like to impose, but in terms of anything that can actually be enforced, it must be in the bylaws. You would think that that would be the end of it, and it's like, okay, well, if they're in the CMS under the magical heading bylaws, then that's it. Those are the bylaws, we must comply with them. But there's another section of the legislation, section 180, and I'm going really fast now because I know that Grant's going to cut me off. Section 180 that talks about what the limitations on those bylaws are. So just because they're in your CMS doesn't mean that they're valid and enforceable. So when the scheme is a twinkle in the developer's eye, the developer comes up with all these bylaws that are probably just a precedent that's cut and pasted from their lawyer's database, and you'll go, hang on, we don't have a tennis court and we don't have 6 lifts, why have we got all these bylaws? So you have to make sure that your bylaws are necessary and reasonable for your scheme, and some of those rules include, in terms of limitations on bylaws, include not being able to impose a financial obligation on lot owners, to have to be necessary and reasonable, not oppressive, and to not discriminate against any particular class of owners. So I think that's a more apt description of what a bylaw is.
Thank you. Andrew?
It'd be fun, wouldn't it, to... Can you hear me? Yeah. It'd be fun, and we could do this. We could put together some make-believe bylaws for a scheme, and I'd be tempted to accidentally get a committee to sign off on a CMS that had these in it. You know, you can't have a dog, but you can have a camel. Now, or you can't wear orange shirts to committee meetings. Bylaws can be as ridiculous as you like, and they'll be recorded in the titles office because the registrar has no obligation to read the bylaws when you submit your community management statement. So you can have anything, absolutely anything in those bylaws, and then you as a committee, and this is the tricky part because you've got an obligation to enforce the bylaws. So if someone's wearing an orange shirt at a committee meeting, you'll have to give them an infringement notice, and you'll have to go through the process of breaching them and enforcing the bylaws up to the point where an adjudicator says, well, I'd really love to assist you, committee, however, this bylaw is invalid, and instead of giving you the order that you're seeking, that this person mustn't wear an orange shirt to a committee meeting, I'm going to instead give you an order that this bylaw is invalid and you must replace it or delete it from the community management statement and record a new one. But for the purpose of the exercise, we could do that. We could make every single bylaw in your community management statement invalid, and we could lodge it at the titles office, and it would be recorded as a document that a purchaser could get their hand on and read the bylaws and go, these guys are wackos, I'm not buying in this building. So we could theoretically do that. And the only point of that concept is to remind you that your bylaws don't necessarily, just because they're recorded in the titles office, doesn't necessarily mean that they are valid and enforceable. Now, what's the question I'm supposed to be answering?
Well, I think you've covered it.
Why are they necessary?
Yeah.
Well,
yeah.
they're necessary, as Eric said, only on occasions when he needs to remove them from his bottom drawer because people aren't doing the right thing. Community title schemes are generally a lot of people living in close proximity, and so the difficulties we have as humans getting along with each other is exacerbated because there's more of us living in close proximity. So I think that's one of the reasons. Taking a step back, why do we need laws at all? Well, one, we're all scared of death, so we want to avoid dying. So, for example, we have a bylaw that says, "Thou shalt not kill thy neighbour." We're also worried about losing money, so we don't want our investment to fall down or catch on fire. So we might have a bylaw that says you cannot light bushfires in your dining room. And the other thing is more about comfort. I mean, we want to be able to relax and enjoy the comfort of our own lot without people smoking next door or barking dogs or, jackhammers going at midnight. So they're the reasons, I think, three main reasons that I think we need bylaws. But then by the end of this presentation, you might think, when we answer the question, are they worth the paper they're written on, you might have different views about whether or not they are necessary.
Mm. Yeah, good answer. And Chris, do you have anything to add? Like, I was just thinking, we've got our local laws. Is there any reason why we can't just rely upon them, say?
Sure, we could. I might answer that by sort of sharing a rarity in my world, which is a question that I'd never been asked before on a Strata issue, and I got this just yesterday from, if anyone's familiar with the blog site, Look Up Strata. And the question posed to me there to answer on behalf of the person asking it was, are children allowed to swim naked in my complex's swimming pool? Now, I was seriously flummoxed with that one, and the full answer will be published next week, so building up a bit of suspense there. I suppose the point being that we can talk, and this picks up on what you were just saying, Andrew, we can speak all we like about necessity and about encouraging appropriate behaviours and all the rest of it. And then we're confronted with an instance of, I don't know what you would call that, human behaviour of a sort. And is that up to the body corporate to even be involved in a situation like that in any event? It's happening in the body corporate, it's happening on common property. Presumably it's having an impact on people who live there. Is that a body corporate issue though? I don't think it is. So coming back to the question, why are they necessary? They're necessary up to a point for defined things. After a certain point, they cease to have relevance. Yeah.
Bit like the bylaw that you're required to supervise children and not let them scream.
That's a great one.
Yeah. So.
No child should be unsupervised or left to scream unsupervised.
Yeah. So they can scream while you're supervising them, though. Right. All right. Well, this moves us on to when things do go wrong, how are bylaw breaches reported? And I'll ask Eric to start this one off because I'm sure as a resident manager, you hear lots of, well, not in your complex because it's very well run, but you probably hear stories about these things being, bylaws. Sometimes people don't do what they're supposed to do.
And I'd share, living in Strata is a relationship lifestyle. So whether you're talking the relationship between the body corporate and the on-site manager and the guests and the people who are living in the complex, and all of this is an intricate web of relationships. And so when we talk about how a breach is reported, often it's the hair on fire. Someone comes in and they have lost their mind over a topic. And whether it's even a bylaw or a breach or a breachable offence is irrelevant at that stage. They're reporting to the on-site manager that there's something occurring that is not of their particular favour, and as a result they would like something done about it. And so the actual act of, we'll speak to that, but the process of reporting a breach it can take a million different, we all know there's a way to do it. And there's we've got a draft, we'll get into that. I'll let the lawyers talk about that. Yeah, the boring legal stuff on how to actually apply a breach. But the initial expectation of most people when something's not going right is, please someone just fix this. Make this problem go away. And so as an on-site manager of 12 years, and as somebody who's worked collectively with probably 200 different on-site managers and done presentations like this for 12 years, it's a significant challenge just to accept and receive some of the frustration and feedback that comes from the guests or the people living in the complexes, and then ensuring that they realize that we are not necessarily the police of everything that is going on, but we want to do everything possible to bring harmony back to the scheme. And so the act of actually how our bylaw breach is reported, I would honestly tell you that in most cases, it's through some extremely frustrated or heated sharing of a message to an on-site manager or perhaps to a body corporate member who lives in the scheme itself. And that's how it starts, because people are comfortable until such stage that they are no longer comfortable, and all of us respond differently once we've reached our level of discomfort. And so that would be the best way to reply. And then the most important thing, if that is the definition of how a breach is reported, they report it to me, the most important thing is how I respond to and how I initially receive that particular piece of feedback. Because if the first thing I say is, I'm just the on-site manager, this isn't for me, take it back with the body corporate, we are going to have a situation escalate rapidly. And so anyone who's worth a pound of salt, who's either managing a complex or sits on a body corporate, realizes the first thing you do is nod and say, I appreciate and thank you for bringing this matter forward. Either leave this with me for a moment, and I'm going to get you some feedback on how we properly report this, or allow me to try to work on addressing the matter. And a good on-site manager is going to go and try and address that matter in the best way possible, but there come moments where it goes beyond what an on-site manager can do. So that would be phase one of reporting of a breach.
Yeah, and similarly to Eric as on-site manager, as body corporate managers, we do receive reports of bylaw breaches. But what we can talk about, and I'll ask the lawyers in the room to talk about the formal process, which will then lead into the next question, which is about policing bylaws and the importance of making sure that initial reporting and what information is reported is sufficient to take it to the next stage if it does need to be taken to the next stage. So either of the lawyers in the room like to add to that?
Yeah, so the process, I like Eric's process, and last time I sat here with Eric, I said, I need an Eric. And I think some of you may agree with me that, the first point of call, the building manager, if you've got a good one, you don't even hear about bylaw breaches. When you have to ring me, then you know you've really got a problem. And so the process generally is someone reports a bylaw breach. It might go to the building manager, it might go to the body corporate manager, it might go to someone in the committee. And it might just be a phone call saying, we've got this problem, there was a party last night, and the person keeps partying, whatever the problem might be. The committee is ultimately responsible to enforce the bylaws, and the proper procedure is for an owner, and it's, how can you ever get bylaws enforced when you've got to go through the paperwork? An owner has got to download, print out, sign what's called a BCCM Form 1, which is bringing the bylaw contravention to the committee's attention. They give the form to the committee. The committee's got, 7 days to decide whether or not the committee is then going to take it upon itself to enforce the bylaws. If the committee decides that it's not going to, then the person who gave the Form 1 to the committee suddenly has standing to enforce the bylaws themselves. So if the committee doesn't want to help you and you're a lot owner who's got a problem with your neighbour, then you don't have standing now to commence proceedings against that person. But if the committee doesn't help you, then somehow you get standing to commence proceedings against that person. In the ordinary course, the committee would then, once it's got a Form 1, it would decide whether or not there's enough factual evidence to establish a breach and whether or not the committee is going to go on and enforce that breach. If it does, it's got to download one of two forms. There's a BCCM Form 10, which is for continuing contraventions. So if the person has enclosed their balcony, for example, it's continuing, it's not moving. Or there's a likely future contravention, which is the BCCM Form 11. And under that form, that's used for things like parties or dogs barking. It's not happening continuously, but we think it's going to happen again because it's happened 50 times in the last week. So then we would then, as a committee, have a meeting or resolve outside committee meeting to give that form to the offending person, alleged offending person, and we would give them some time to comply with that order if it was with that notice if it was a Form 10, or we would say don't do it again if it was a Form 11. Then if they do it again or they don't comply, and the compliance might be getting approval from the committee, it might just be stopping or dismantling what they've done, who knows. If they don't comply, then the next step for us is to take it away, James. I'm taking up too much time. You take it from here.
That's okay. I was enthralled. I was just sort of reminiscing about how forms make for happy people and harmonious communities. Because if there's anything that's going to bring people together, it's getting a form that says you're in breach of the bylaws. So
sorry to interrupt, but what I find very interesting of all those forms, the notice of a bylaw breach is Form 1. It's the first one.
Yeah, but they had high hopes for how people would coexist. The first order of business, notice of breach of bylaws. So I'll go backwards to go forwards. What I would say is that there's a practical answer to this, which was sort of canvassed a little bit earlier, but both in terms of it is just a good community-minded and generally decent human thing to do to try to talk to somebody about an issue before you go and issue them with a form that's far more likely to make them more aggressive and petulant than less. But it's also the start of the process for self-resolution, which is one of the things that you need to be able to demonstrate that you've done before you go down the enforcement of bylaw process. So if you are the person complaining and the committee hasn't agreed with you and you now have standing, as Andrew said, and you go off and make your own Commissioner's Office application, one of the prerequisites to that form is to say, look, I've done all the things that I need to do in order to try and solve this myself, and detail that. It's not just a ticker box. The Commissioner's Office is very strict on making sure that you've tried to self-resolve. The other practical reality is you may actually self-resolve it, which would be even better. So assuming that doesn't work and either the committee or you as the complainant go down that adjudication process pathway and you've ticked all of your boxes, even though I said it wasn't a ticker box, you've met all the requirements of the form and you're away with adjudication, then I won't go through the whole adjudication process, but essentially someone many months to years later will make a determination about whether that person is actually in breach of the bylaws or not. And as Andrew said earlier, sometimes they'll send you back and say, well, actually, your bylaw is invalid. And then let's say we're successful and then we serve a copy of that order on this person who's by now, got smoke coming out of their ears, and they happily and gleefully comply with that as soon as possible and thank us for the process. Most likely they don't and they ignore it. And then you get to undertake another process where you then take that order that you got from the Commissioner's Office and you go off to the Magistrates Court to enforce it. And after much effort, time, legal costs, and depending on what the issue is, you may well then get an order from the Magistrates Court saying, yes, you really must comply with that adjudication decision. And then they happily and gleefully go and do it. But in the event that they don't, then there's a whole heap of other stuff that you need to do. And one of the things you can potentially do is have them imprisoned, but that doesn't actually happen.
So we're getting into this territory of who are the bylaw police, because they're the ones that are going to start enforcing that. Please correct me if I'm wrong here, but I thought that there's a new role where you hand out a little badge and you've got a clipboard, and that person is appointed by the body corporate to be the bylaw police. Is that true, Eric? You got that?
Yeah, I have 5 of those badges in my office at the back. And,
Sometimes a little. So the higher level, you get a little hat.
Yeah. There's levels and colours. Yeah.
Right.
Look, in all seriousness, all of you are in this room because specifically we want to talk about what happens in the world of bylaws, and these fine gentlemen can walk you through every single stage of what you're going to need to do in order to get some sort of hope for some form of rectification of some sort of problem. But when it really comes down to it, while all that is taking place, there's an on-site manager, there's an angry body corporate member, there's an angry owner, there's an angry someone, and it's festering. And it's festering, and it gets worse and worse and worse while this process happens. And when you think, as the body corporate chairman, or as the person who's done the complaint, or the person who doesn't feel he feels he's being wronged, they're getting more and more frustrated and angry, and then it actually goes well and beyond the whole issue of whatever we're writing on a piece of paper that we're upset about. Okay, so 12 years I've been watching this all take place, and so the message that has to go back to everyone is what we should do is forget investing in all of the paper stuff and invest in a whole lot of counseling. Because if you can legitimately, early on in the process, just narrow it down to the thing that's really causing the problem and determining in a calm and reasoned manner, is there or is there not a way to rectify this problem? At that stage, you're going to know right away if you're going to have years and years of discomfort in the world of strata title living, or if you're going to have months and months or years and years of paperwork and paperwork and paperwork and a ruling and a this and a that, and then they don't agree with the ruling, and then they're going to appeal the ruling, and then, but all the while that's happening, you're getting more and more frustrated, and you're getting more and more upset, and now you're upset about other things because they didn't talk to you nice, or they didn't nod at you in the elevator. And so this is the part of the bylaw piece that for me as an on-site manager, I just keep going back to. This is a communication world that we have to live in when you're in strata title. And so
And what you're talking about, Eric, is also part of the prerequisite before we, all this is great and hopefully it works, but when it doesn't and it all goes wrong, I'll ask Chris, particularly since, your position as former commissioner, when it does go wrong and unfortunately do need to go down that path of enforcement, we talked about the right way of getting the paperwork already and everything else, the right forms to tick boxes. What then happens, and what are the options, prerequisites before it'll be heard, or and then if an order is made, who then makes sure that actually is followed through?
Probably one thing I would say is just to sort of pick up on both what Andrew and James were talking about before. My former office has published a bylaw enforcement flowchart. So think of it as the idiot-proof guide to enforcing bylaws. It literally is step by step by step. You just Google BCCM bylaw enforcement flowchart. That will take you it. I can tell you it's the real thing because it was vetted by adjudicators and it was the subject of weeks and months of argument in the office at the time about. So that's that one. It all begins with everyone here has talked about communication, and that's where it always starts, and eventually it always ends too. The point about trying to bring up the issue with somebody is a really good one. I'll share an anecdote from my own experience. I used to live in a community title scheme as a tenant in the Valley in Brisbane. I might have mentioned this story before. It's party central in the Valley. It certainly wasn't party central at my place, but it's party central there. And one night there was an especially big party at the complex. I know because I heard it right up until the early hours. The next business day it might have been. So rather than some kind of aggressive knock at the door and various accusations to the hungover blokes who caused the party in the first place, the on-site manager, presumably under instruction from the committee or the corporate manager or both, put a note in everyone's mailbox. And the note said, I'm paraphrasing here, the bylaws for our building are that between 10 p.m. and 6 a.m, no noise, just in case you weren't aware of it. That's significant because the manager was then establishing the benchmark for everyone. You can't turn around and then tell me you didn't know what the noise bylaws were because I told you because I put a note in your mailbox. You're also not accusing people. You're also not saying, I'm sending you this because Billy and Frank in Unit 10 can't be trusted to keep the noise down. So anyway, an explanation about all of that, and it ended up by saying, if you want to go and party, there's a great bar up the road, take it up there and enjoy your night. Did they have to do that? No, but they did it because of everything that I just said. that's an example of putting into place a communication strategy that addresses the issue, or hopefully addresses the issue. But if you do need to take it further, you can, but you can also point to the fact that you made sure everybody knew about it. Nobody can turn around and deny. And denial is a big part of body corporate living, sadly.
Okay. Anyone else have anything to add on that bylaw police aspect?
Probably something, and I'll apologise for probably stealing some of Chris's thunder there in my enthusiasm earlier, Chris, so sorry about that. But probably something that's important to note is that particularly in an age where, you know, people can not just slip notes under people's doors, but they can jump on things like Facebook and make comments about things, and there's some schemes that have their own sort of Facebook pages or their own portals. Just really important to make sure that you don't report the breach of bylaw in a way that's so public that the person who either is named or can be ascertained who their identity is could then give you a defamation concerns notice. So the importance of following the process, as much as I sort of poked a bit of fun at forms before, the good thing about forms is that if you follow the appropriate process, then you won't fall foul of other laws. And I've had occasions where you know, people have been lined up for defamation. It's an incredibly stressful thing for them. So just stick to the right form.
Okay, and before we get into the alternatives, which we've touched on quite a bit already, just to close off on this enforcement, and for the audience, it's a common question that we get as body corporate managers as well, where you've got an occupier or an owner, but you've got somebody breaching the bylaws. Who actually gets that Form 10 or Form 11? And just on those different Form 10s and Form 11s, you've got two different types. So when do you need to reissue it, or how long does it last? What's the notice periods?
I just want to tell you a story which I wrote. It's an edgy article which I published a couple of days ago, and if you look at my little brochure there, you can look it up on the website. But it's based on a potential bylaw breach. I live in a community title scheme, and it is a holiday, short-term letting style building, and the apartment above me isn't in the letting pool. It's run through a private agent, and they do use Airbnb, but that's sort of irrelevant. But I was sitting watching a movie with my daughter a couple of weekends ago, and this noise started upstairs in the bedroom above us, and it was like gradually increasing in tempo and volume as the bed head hit the wall. And I resolved it myself, and you'll have to read the article to find out how. To the bemusement.
So you didn't take a Form 10 up and knock on the door, excuse me?
And all of those thoughts crossed my lawyer's mind, and thought, how ridiculous is the process in circumstances like this? I almost said in circumcisions like this, but so back to the point again, and this thought crossed my mind also. If I were to slip a Form 11 under the door, it would be defective because I don't know who these people are. I couldn't go and talk to the building managers who I know and ascertain from them the identity of the alleged offenders because they're not in their records, because they're, the unit's privately let. So to answer your question, Grant, the only way that I could, going through the process before, I could give a Form 1 to the committee and say someone was causing noise in the unit above me after hours. What are you going to do about it? But again, the committee would have the same problem. They don't know who these people are. So,
And you'd need a recording of that too, wouldn't you?
I didn't actually go that far, but yeah. you'd probably need some sort of evidence. And in those circumstances, I think, and depending on how your bylaws are worded, but even if there wasn't a bylaw that assisted, you would give the you'd give the notice to the owner because there's no one else to give it to. And I guess the bylaw would be you've allowed your invitees to breach bylaw whatever. Please don't allow future invitees to breach that bylaw. And how do they comply with that? In the article I said maybe hang a sign over the bed.
So, and on those two different forms, just so everyone's aware in case they come across this circumstance, would this be a continuing or likely future? And what's the time frame for remedy or for reissue?
Yeah, well, that's the thing, isn't it? So to answer that question, and I know that you're joking, it was fairly continuous, I might add, but it was, yeah. I thought about that, but that wasn't the answer. You'll have to read the article.
We're republishing that tomorrow, by the way, so you don't have to wait too long.
Look out for it. It's called Symphonic Sex and Self-Help in Strata.
It had to be heavily edited.
There's some analogies between, playing loud music and doing what they were doing. So, there was some singing involved, I think. Anyway. To answer your question, Grant, the form would be a Form 11, please don't do it in the future. And then if they did repeat it, then that would be a breach that we could then take the next step, potentially.
Yeah, so they got 3 months where that's in force, 3 months, 1 day, new form.
Well, they'd need to repeat it before we could then give them another form. So, there's a lot of boxes to tick.
And then when you've got the notice of continuing, so you've got a period where it needs to be remedied by. Is there a regulated period, or how do we work that out?
Well, I think the body corporate's got to act reasonably in anything that it does. So I think depending on what the circumstances were. So let's say someone had, using the example that I used before, enclosed their balcony. It would be unreasonable of us to potentially to request them to remove those improvements within 7 days. We might say a month would be reasonable to engage a contractor to come in. I mean, they're not going to do it.
No.
So, but if we don't give them reasonable notice, then our form is susceptible to invalidity, and we'd have to start the process again. So we just have to use common sense, but give a reasonable period of time for compliance. Would you agree, James?
Yes, well, to use your example of earlier, if it was the situation you were talking about, I think the reasonable notice period is directly proportional to the attractiveness of the couple.
It is actually possible to enforce a bylaw if you don't know who the person is. So you can enforce a bylaw against, quote unquote, the occupier. You would need to demonstrate that you made some efforts to find out who they were, though. But I have seen orders made against the occupier.
Okay. Well, we're getting into the Love Thy Neighbour, and thank you for the story, Andrew. Lots of loving going on there. So we've talked about some alternatives, and from what I'm hearing, it seems as though it's about that initial, when somebody's doing, potentially doing the wrong thing, allegedly doing the wrong thing, the approach, would we say, and also setting expectations about what's acceptable and what's not. And we talked about those house rules earlier, Eric, just giving them some plain English, I suppose, parameters.
I mean, obviously, as an on-site manager, it's easy at 10 o'clock at night when something's going on. We're 24/7. You contact you would contact the on-site manager. We would go, and a good manager is going to get up and go and look after addressing if there's a party going on. And so you will shut it down, and you will give them reason to shut down, and you will do everything you can to continue with harmony on the scheme. But in 12 years of doing this, I've only we've ever issued one breach notice, and it was an owner-occupier who was basically he'd sleep all day and he was a night owl, and he was choosing to build a soundproof room where he could do his drumming inside his unit. And so the problem was not the drumming. The problem was the construction of the soundproof room, because post-construction, he's actually drums his mind out and nobody can hear a thing. So he's done a very good job. But during course of construction, it caused a whole lot of grief for all those people involved. And frankly, he didn't care. He was going to get through this process and he was going to get his soundproof room and then there would be no problems, and there are no problems. But I guess the point would be there are so many different ways in which people will breach a bylaw and not know they're breaching the bylaw. And then it's a behavioral thing where you go and say, thank you, you're having a good time, but you got to respect the people around you. And so most 99% of the time that all shuts down. When you have someone who has a dead set plan on what it is they're going to do and nothing's going to stop them, they know the systems and how to work the systems, and they will usually get to the end result or try and get to the end result, and it doesn't matter how many people they've offended. So the act of just loving thy neighbor comes in a lot of different shapes, as we would all be aware, but it's just so important to understand how to properly manage the initial complaint, and whether it's a full-out breach or whether it's just the start of something that could become a breach. That's the essential part.
All right. Anything further to add, James?
Yes, I'll add in a quote which I didn't vet prior to this, so it's good that this is being filmed. But I think it was John F. Kennedy that said, when you maintain peace at the price of dignity, what you have is no longer peace. So I think there is a point where you sort of say, well, you can love thy neighbour, you can try to discuss this, but at the point in time, there are some people where, and again, I'll be careful of my reference because we're being filmed, but there are certain policies of the past of appeasement, and certain people were, in history, tried to be appeased by others, and they just took more and more and more until all-out war ensued. So I guess making sure that, as a body corporate and as a committee, there is some reasonable measure by which you kind of say, at this point, it is actually in the best interests of all owners and the scheme for us to actually put down the love thy neighbour approach and actually go through the enforcement approach.
Great. And just finally, Chris, did you have what's your view on love thy neighbour? Is that the approach?
Anyone who knows me reasonably well will know that I'm not a love or cuddly person. So it's a bit no, thank you. It's an odd one for me to be answering. I guess I come at this from a couple of perspectives. I don't think there's any place for love in a body corporate, notwithstanding your anecdote, Andrew. You're not there to make friends. You are there to protect your investment and hopefully grow it. Now, along the way, if you happen to establish good relationships, great, fantastic, happy days. The minimum that you need is respect. And what I mean by that, it's the minimum amount of interaction that you require to transact the day-to-day business of a body corporate. That's what it all boils down to. It's not about love, and I'm sorry, but it's not about feelings either. A couple of other points to note there. I am a word nerd. Words are my thing. Always have been, and I dare say they always will be. So here's a fun fact for you. The word breach doesn't appear in body corporate legislation anywhere. There's no such thing as a breach. And when you think about the word breach and you repeat it to yourself and you hear it in your mind, it's a violent, ugly word. Breach. Think about it. It's explosive. I think the correct technical term, it's full of plosives in it. That's why phrases like contravention are preferable, because, and again, you might say to me, what crap are you talking about, Chris? It actually has a point. If you are enforcing a bylaw contravention against someone and it is about their dog, for example, and you refer to their stupid, smelly, ugly mutt next door, that's not going to get you as far as it would talking about a canine or just a dog. Equally, if you refer to the big pile of crap in the car park, that probably won't do the trick either. Those are extreme examples. My point being that words are everything in a body corporate. The words that you use, where you use them, how you use them, the manner in which you use them, it's everything in the way in which you interact with each other. And I've seen so many examples time and time again where people have chosen their words poorly or have not thought about the words that they were using, sent off the email, And the reaction, well, it speaks for itself. And one final point, I suppose. For me, in my business, the work that I do, the one question I always ask anybody is why. So you tell me all about this particular person at your building, owner, occupier, caretaker, lawyer, who you are having some difficulties with. And you explain the behaviour, you explain what's going on. My first question is always why? Why is this happening? What's motivating them? Because in my experience, in the vast majority of cases, any problem that presents itself in a strata scheme has its origins way back in the sands of time. 6 months earlier, 12 months earlier, 2 years earlier, or even longer, something happened, innocuous as it may be, which has set that person on the path to where they currently find themselves. In order to, and my strong view is in order to address the now, you actually have to address the past.
All right, well, thank you, guys. So now brings us to our Q&A section. And just to, I suppose, manage expectations and questions that we do have in the room, what we're asking is that you, if you want to have a conversation, that's okay, but we want to try and make it fair on everybody in here that does have a question. Speaking of which, can you just give me an indication if you do have a question? All right, that's great. So I'll just grab one of the microphones, and we've got the lovely Hannah coming around. So if we could start off, we've got about 20 minutes to get through. Gentleman in the front here with his hand up. If you've got a specific presenter you'd like your question answered by as well.
Not really a specific, just how easy is it to get rid of a bad bylaw?
You just need a special resolution. So you need to, well, there's two ways you can do it. One, you can call a general meeting, and if you're an owner who's got a problem with the bylaw, you can submit a motion before the end of the financial year to be considered an AGM, and the motion would just be to record a new community management statement which removes that offending bylaw or amends it in a way that you want to amend it, and it's a special resolution. So more than 2/3 of the people voting have to vote, more than 2/3 of the people voting have to vote in favour of the motion, and not more than 25% of the ownership can vote against. And you can look at contribution schedule lot entitlements when you're making that assessment of the 25% as well. So if there's a big chunk of owners who vote no, then it won't get across the line. If the motion is successful, then you've got to record a whole new community management statement at the titles office. So you can't just amend it, you've got to submit the whole document again. So that's one way to do it. The other way is to seek an order from an adjudicator that bylaw is invalid and that the body corporate must record a new community management statement that removes that bylaw. So if you don't get your special resolution at a general meeting, that would be your next step. You commence proceedings to get an order that it be removed. So you might be the only person who thinks that bylaw is invalid, everyone else votes you down, you still got a chance to get it removed.
Great question, and same with adding you've talked about getting rid of a bad bylaw. If you want to add a good bylaw, same process. All right, so we had a question on this side, so we'll alternate. We'll get Hannah running around.
Soon, yeah. Take up the speed.
I own a unit on the Gold Coast. There's 180 units in the complex, and there's about 40 or 50 that are rented. And over the last couple of years, there's been some problems with Airbnb and other short-term rentals about getting access to the property late at night. Is that sort of being addressed in the on the strata scene these days, or it just seems to be ongoing and it's been happening in our complex now for 2 or 3 years, and we don't seem to be any further advanced than we were 3 years ago.
Yeah, look, unfortunately, Airbnb is something that has not been well sort of regulated by strata laws. In fact, there's been a series of decisions that have suggested that any bylaw that tries to say ban short-term letting or Airbnb would not be valid. I did see an adjudication a few years ago now where one of the things we talked about under Section 180 earlier regarding the validity of bylaws, there was an adjudication decision that essentially said you can't ban short-term letting or Airbnb, but you can regulate it, and so you could choose to regulate it in such a way that you could get, information of, when the lot's being let out and, copies of certain documents and things like that that might make later enforcement easier. But I think where we're at now is that most local authorities are taking this on as an issue for themselves. So it's really a planning issue. And so some councils, I think the Noosa Council's actually been really proactive in this regard. Gold Coast City Council is starting to get on board. In fact, I saw something in the last couple of weeks where Gold Coast City Council actually appears to be calling out for community feedback on this issue. So I would say start with a council complaint, and that would be the best option. Andrew, do you have anything further to add to that? Yes.
Well, particularly as a Noosa local where there are local laws about Airbnb.
And that's sort of good for us because we don't have to do anything about it from a body corporate perspective because Noosa's very proactive in that field. We've been, I don't want to give away too many trade secrets in front of James, but we have been instructed by a few clients to draft some, I'll say, no, cutting edge is wrong, potentially invalid bylaws that address some of the things that James was just saying, applying conditions, and as we said at the beginning, we can have any bylaw we like in the bylaws. It's just a matter of whether or not it'll be enforceable. So we could have a bylaw that says no short-term letting, but we know that that bylaw is going to be invalid because of Section 180, whatever it is, 4, which says if a lot can be used for residential purposes, you can't restrict the type of residential use. In other words, if it's a residential lot, you can't say long-term only. So the types of things that we've been instructed by people to say in those bylaws are you must provide us with the name and contact details of the guests. You must provide us with the contact details of any agent who you use for your unit so that we can contact them in the event that there's a ruckus and we need to deal with it. You need to get the written permission of the people in the lots around you and inform them that you are doing this so that they can have an opportunity to increase their insurance. Things like this to deter community support of short-term letting.
Well, we could probably continue that conversation later, but just to continue the questions, I did see we had a gentleman over here with a striped shirt. No? Oh, we've got one here then. Here we go. And then we'll go to the other side of the
Just following up on that one then, can we stop someone putting a lockbox on the building if it is not in our bylaws?
I might have a conflict of interest in relation to this one.
Depends where the lockbox is proposed to be put. If the lockbox is proposed to be installed on common property, which I would assume that it would be, then there are rules about making what is called an improvement to common property. That would be an improvement to common property. There are various conditions and qualifiers that go with making an improvement to common property. It largely comes down to the value of the work. It also comes down to whether or not that improvement would cause a nuisance or would conflict with bylaws. So if you have a bylaw which says, did you say that there was a bylaw?
No, there's not.
Okay. So unless you can somehow show that the installation of that lockbox is going to conflict with a bylaw of some sort or cause a nuisance or hazard, and I think you'd be struggling to do either, then I don't see how you could stop it unless there was something else that we didn't know about your building that caused a problem. But basically, that's what it boils down to.
Okay. Question over this side, just hands up.
What do you do when the government regulations overcome your bylaws? Like we say there's no pets, but now the government says you can have pets.
Good question, because there has been some new regulations with tenancy laws.
Yeah, well, that's another thing too. But the other thing that's coming up at the moment with us is smoking. Has the government actually said that you can't smoke on balconies yet? But it's being proposed, isn't it?
I'll go with that. The answer is no and no on both of those. Government hasn't said that you can have a pet, and government hasn't said that you can't smoke on balconies. What has happened is that from the 1st of October, tenancy laws in Queensland have changed, which make it near impossible for a landlord to refuse an animal. The process for a body corporate, though, has not changed. The body corporate process for approving keeping an animal on the scheme has not changed. So no, nothing's changed there. In relation to smoking, there was others might disagree with me, but there was what I would call a landmark decision late last year, early this year, about smoking on balconies where secondhand smoke was found to be a hazard. That's the first time that has occurred. In my view, that effectively renders smoking on balconies virtually impossible, but the government has not actually legislated for that. Both of those issues are absolutely on the government's agenda at the moment to do something about. If you were to ask me what's the likelihood, I would say it's highly likely the government will allow bodies corporate to prohibit smoking. I can't see them doing the same thing for pets though.
Okay. Next question. Hand up.
While you're getting the next question, just one extra thing to add about that last question. One of the prohibitions of bylaws is that they can't be inconsistent with the Act or any other act. So if there's a law and the bylaw says the opposite of the law, then the law takes precedence.
Okay, in the front here.
Listening to you four gentlemen this evening, seems to me that the root of the problem is, from the start of whoever the developer is, there should be some sort of consultation or monitoring, like you gave the example of invalid bylaws. There should be something there to stop it, and a lot of these problems would be resolved at the root of the problem. I mean, being a conspiracy theorist, maybe the legal people like this because it's...
But good point you've made. Perhaps we can expand on, because sometimes we see bylaws and there's a requirement to put a bylaw in that points out things that are in the development approval, such as not enclosing balconies.
I don't want to hog the mic, but I'll just quickly. Well, our firm acts for both developers and for bodies corporate afterwards. So the conspiracy theory is probably not too conspiratory. So yeah, we definitely set them up so they were bad so that we could fix them down the track. That's a great idea. Thank you for that. No, but I agree that there are certain mechanisms in the legislation that give fiduciary duties on developers to, for example, ensure that the caretaking agreement between the body corporate and the building manager is fair and equitable. And in circumstances where it's not, the body corporate and people who are affected by that can take action against the developer. But there's nothing in there about bylaws, but I agree that there probably should be. One of the reasons that there's not is because over the last 10, 15 years, the policies have been to reduce regulation and reduce red tape, so it's easier for developers to just build more strata. And if they have to go back and get their bylaws assessed by some independent person, it's going to cost them money, which, great, they should do that, and then people will pop up who do that for a living. But yeah, I agree. Perhaps the way to deal with that, and you've got the right as a body corporate at any time to review bylaws and fix them and change them however you like. Perhaps there should be, and again, I sound like I'm making a job for myself, but perhaps there should be, after the 3rd year anniversary of the scheme, a motion that's got to be submitted. Do we want to review our bylaws and make sure that they're appropriate for our scheme? Because as Grant said earlier, sometimes there's bylaws that say, you know, you can't swim in the swimming pool between these hours, and we don't have a swimming pool. So things like that, there's definitely a need to review them. And I think generally, again, I'm trying to make work for myself. Generally, I think there should be an obligation for bodies corporate to update their bylaws on a regular, or just review them on a semi-regular basis, because things change. There weren't drones 10 years ago when a scheme was established, and there weren't the type of technology and things that are available now that might annoy other people or that should be regulated. So yeah, I agree with your comment.
Just hand up in the room if you have another question, just so, because we've got limited time left. So I've got one over the back here. Was there any on the other side here? All right, another one over here. Any more over here? Right, so we've only got 2 left, possibly a third. Thank you.
What do you think? What do you think about a designated smoking area for those smoking on the balconies or even inside the units, and the smoke drifts out anyway?
Well, I think that goes to the reasonability point. I mean, one of the difficulties of issues like smoking and pets and all the other things is that you're weighing up private property rights. And so, you know, someone has the right to enjoy their property, and they might enjoy smoking, and so that's a right that they may have, but that right may impinge upon other people's rights. So I think ideas like having, you know, designated smoking areas, you know, make sense. Some of the sort of decisions in this area, when you're talking about smoke drift and validity of bylaws, have dealt with issues such as, you know, do you have a blanket ban, which is seen to be the wrong approach, or do you try to regulate the behaviour by saying, put measures in place to stop smoke drift? What's the real harm that we're trying to deal with here, and get to the root of the harm rather than completely preventing, you know, that behaviour? So probably a good compromise and a sensible approach.
I like the idea of the smoke room though. Maybe a wine room as well.
But you must wear smoking jackets in the smoking room.
We had another one over here. Here comes the microphone.
Should electric vehicle charging be put in part of the bylaws? Because if people start, we're an older building, we're not set up for it. And if people want to start doing it, it's a significant cost just to the body corporate. Should we put it in the bylaws to stop them doing it, or is it outside the bylaws?
So a bylaw that says you shall not install electric vehicle charging.
Yeah, we're in 2020, we were pulled up in 99 or 2000, and there's nothing like this.
Depending on what the sort of effect to the building's infrastructure is going to be in relation to the charging, there may be other issues such as improvements to common property and other safety issues that might trigger body corporate approval being necessary for electronic vehicle charging in any event. And EV charging and things like, you know, solar panels are potentially issues that can affect the body corporate in circumstances where, let's say, there's limited infrastructure. Do the people who get in first get a better deal than others who are sort of later to the party? So my approach to those types of issues is always be really proactive. So as a body corporate, make a decision about how you're going to address EV charging, because it's coming whether you like it or not. Then it becomes a matter of going, well, let's get appropriate experts to tell us what our building can handle, what the upgrades might look like, then get the necessary approvals in order to allow that, and most definitely have a bylaw. It will need to be a regulatory, not a blanket banning bylaw, but have a bylaw that's going to regulate how those approvals take place, so that it's fair and equitable for all.
I can see around the room a lot of ears being, you know, spiked by that question, and I just have just to continue that one as a final question before we get into the next section. Sorry, Eric, if you can let us know what you're seeing within the industry, the growth of it, and people investigating that sort of thing within strata buildings?
Yeah, so for for my complex itself, we were already in the process of finding ways to bring 2 or 3 stations in. We're looking at it as both an income stream and as a convenience to those people that are needing and wanting those kinds of facilities. We happen to have a lot of space that we can work with and make that happen. There is definitely a cost, an infrastructure cost to bring it in. I'm working with 6 other complexes that don't have the kind of space, but the people installing them are finding innovative and unique ways in which it can be done. So there's a lot changing in that space, and so I'm involved in it right now on 6 different facilities. So I could at least be a beacon of hope with those people who want to see that and would expect to see it. But it's definitely coming. You can't put your head in the sand and think it's not coming. There's a need. And frankly, as a person who operates on a short-term let basis, if I put 2 e-chargers, if I promote this complex has e-charge stations, it's an attraction to the business.
We've looked into it, and it's going to cost us between 30 and 40,000 just to get the power to the building suitable. Because at the moment, we were built 20 years ago, and the power isn't sufficient to do it. If anybody goes and installs one on their own, they're going to black out.
Yeah. So if we can talk about the bylaw aspects, and Chris, I'd just like to
just to pick up on your
so as your former office, if you were to if there was a dispute over that bylaw, what's the parameters of what that could say and what it couldn't say?
Well, just to pick up on Eric's point, firstly, at the end of the day, this is about an improvement to your property values. If you've got appropriate EV charging facilities in your building, appreciating how much it costs to retrofit, we're not even talking about new buildings and what obligations will apply there. But if you have retrofitted your building to be appropriately set up for a range of EV, your property values will increase dramatically, I would argue. So that is the counter to the amount of money that you spend on that. There will be some people in the building who will just simply be opposed on the grounds that Elon Musk is an idiot. Well and good. But at the end of the day, you have to put aside those personal feelings and think about the broader picture. To pick up Grant's point, any bylaw that imposes a monetary penalty will be an invalid bylaw. So you can't have a bylaw that imposes a monetary penalty. You would have to think about how that works so that it doesn't discriminate between different types of people. So, for example, you couldn't have a bylaw that only applies to owners with EV vehicles. Sorry, EV vehicles, what a terrible thing to say. But that have EV and tenants that have EV. And just one final point. Government's going to have to step in and do something here, because in the federal budget this week, there was a significant announcement about incentives to purchase EVs, which is great, but you can't have an incentive on the one hand without making adjustments to legislation such as strata legislation. On the other, we have legislation about solar panels, the ban the banners legislation. I think we will see something very soon and very similar to that where it comes to EV.
Well, it seems like that topic is a continuing discussion point, and no doubt there'll be some feedback in your forms about that as a future topic. But we do have lots of people that can talk about this during the networking session. So that brings the Q&A section to a close. So please join me in thanking all of our panel for their expertise. And just a small token of our appreciation. So thank you guys. But I did mention at the beginning of the session, your feedback forms. So I asked you to put down your perception of whether bylaws are worth the paper they're written on beforehand. And please let us know what you think now as well.